मैं अपनी बात करने से पहले आपसे ये बताना चाहूँगा कि हम लोग जो 22nd लॉ कमीशन को जो अपना नोट या रिस्पांस लिखकर भिजाए, उसमें 3 चीज़ें हैं। एक तो एक रिस्पांस नोट है, दूसरा उसमें हम रिटायर्ड जस्टिस वी गोपाला गौड़ा का एक लीगल ओपिनियन जो हम उनसे पूछे 5 क्वेश्चन के ऊपर, वो भी हम उसमें देंगे। और तीसरा हम उसमें एक पोजीशन पेपर में जो 2016 में 21st लॉ कमीशन को दिया था, वो तीनों हम लोग लॉ कमीशन को आज भिजा चुके हैं। तो सबसे पहले यह है कि मैं शुरुआत में मैं शुक्रगुजार रहूंगा हमारे सुप्रीम कोर्ट के फाजिल वकील जनाब एडवोकेट निजाम पाशा साहब का कि उन्होंने हमारी बहुत मदद की इस रिस्पांस नोट को तैयार करने में, बल्कि बहुत ज़्यादा मेहनत उन्हीं की रही। पूरा उन्हीं का पूरी इसमें जुस्तजू थी, मेहनत थी, और उनके ताउन से उनकी पूरी मदद से ये एक रिस्पांस नोट हम तैयार करें। तो अब इंशाल्लाह अभी आपको थोड़ी देर में ये तीनों नोट्स हम लोग आपको दे देंगे। मेरी आपसे गुजारिश ये है कि मेरे को थोड़ा टाइम दीजिए आपको पढ़ के सुनाने के लिए, वरना अगर आप शॉर्ट में चाह रहे तो मैं दे देता हूँ ये आप लोगों को, क्योंकि मैं ये चाह रहा हूँ कि आप नहीं 3 पॉइंट नहीं है, वो ऐसा नहीं है आशीष। देखिए, ये 2 मिनट बाइट नहीं हो सकता, तो आप सुन लीजिए एक 10 मिनट के लिए मेरी बात को, और उसके बाद आप लोग जो भी सवाल करना है करिए। तो सबसे पहली बात तो ये है कि ये जो नोटिफिकेशन 22nd लॉ कमीशन का आया था जून 14 को, जिसमें उन्होंने पूछा कि व्यूज दीजिए ऑन द इश्यू ऑफ यूनिफॉर्म सिविल कोड, मगर उस नोटिफिकेशन में लॉ कमीशन कोई प्रपोजल नहीं देता, सिर्फ उसमें हवाला देता है 21st लॉ कमीशन का। और 21st लॉ कमीशन जो कंसल्टेशन ऑन पेपर ऑन रिफॉर्म्स ऑफ फैमिली लॉ दिया था 31 अगस्त 2018 को, वही उसका हवाला दे रहे उन्होंने, और उसका जवाब हम दे चुके एज हमारी पार्टी तरफ से। तो ये सबसे बड़ी उसमें गलती है, और ये कोई कोइंसिडेंस नहीं है कि एग्जैक्टली 5 साल के बाद फिर से लॉ कमीशन ये एक्सरसाइज को अंडरटेक कर रहा है यूसीसी के बारे में। माने क्लॉकवर्क की तरह हर जनरल इलेक्शन से 5-6 महीने पहले भारतीय जनता पार्टी इस इशू को उठाती है यूसीसी को, और मकसद एक ही है कि एटमॉस्फेयर को विशिएट करना, पोलराइज करना इलेक्टोरेट को, ताकि आने वाले जो 2024 के चुनाव है उसमें उनको कुछ सियासी फायदा मिल सके। अब आप ये समझिए कि जून 14, 2023 को जो उन्होंने पूछा यूनिफॉर्म सिविल कोड के बारे में, मगर वही कंसल्टेशन पेपर के बाद जस्टिस चौहान साहब क्या बोले, दैट अ यूनिफॉर्म सिविल कोड इज नीदर नेसेसरी नॉट डिजायरेबल एट दिस स्टेज। ये बोले उन्होंने। ये यानी इनका कॉन्ट्रोडिक्शन देखो आप 22 लॉ कमीशन का। और दूसरी बात यह है, वो उन्हें बताते भी नहीं कि व्हाट इज अ यूनिफॉर्म सिविल कोड। ये जो 22वां लॉ कमीशन है, बताते भी नहीं व्हाट इज अ यूनिफॉर्म सिविल कोड। 21वां लॉ कमीशन चौहान साहब का, तो वो तो अलग ही ओपिनियन दिए, ये नहीं बताते। अब आप आ जाइए कॉन्स्टिट्यूएंट असेंबली के डिबेट्स के ऊपर, जिसमें इसमें एक साफ तौर से कहा गया था बाबा साहेब अम्बेडकर के बारे में, अम्बेडकर ने कहा था, मैं आपको पढ़ के सुनाता हूं। वन ऑफ द सोल्यूशन प्रपोज्ड बाय बाबा साहेब अम्बेडकर वाज दैट पार्लियामेंट में मेक द यूनिफॉर्म सिविल कोड ऑप्शनल. It will be available to persons who wish to opt out of their personal laws. Dr. Ambedkar further assured the members of Constituent Assembly that Therefore, no one need to be apprehensive of the fact that if the state has the power, the state will immediately proceed to execute or enforce that power in a manner that may be found to be objectionable by the Muslims or by Christians or by any other community in India. We must all remember, including members of Muslim community who have spoken on this subject, though no one can appreciate their feelings very well, that sovereignty is always limited, no matter even if you assert that it is unlimited, because sovereignty in the exercise of that power must reconcile with itself the sentiments of different communities. अब important सुनिए आप, no government can exercise its power in such a manner as to provoke the Muslim community to rise in rebellion. I think it would be a mad government if it did so, but that is a matter which relates to exercise of power and not to the power itself. So, इससे it is clear from the text of Article 44 itself, as the debates in Constituent Assembly, that UCC was contemplated an exercise that involved disruption and upheaval to yield one size fits all, and therefore notes of caution were sounded, including the need for it to temper with optionality. ये एक है. दूसरी बात ये है कि the exercise of the reform of specific personal laws of individual religious communities proposed in the consultation paper, यानी consultation of 21st Law Commission, that it finds its basis not in Article 44 but in entry 5 of list 3 of 7th schedule of the Constitution. Such an exercise of codification or alteration of individual laws of individual communities requires a more focused consultative process with draft laws being placed for comment and the participation of stakeholders from the affected communities being sought. As such, the consultation paper, just by virtue of sheer breadth of issues it has covered, was grossly unequal to the task it set out for itself. अब आप ये देख लीजिए, इसका तो कोई कॉन्स्टिट्यूशनल बेसिस नहीं है, मगर हमारा मानना ये है कि ये एक पॉलिटिकल एक्सरसाइज हो रही है, एक गैर जरूरी के एक माहौल को मुल्क में पैदा करने के लिए लोकसभा इलेक्शन से पहले, ताकि जो तवज्जो है जनता की गरीबी के ऊपर, बेरोजगारी के ऊपर, महंगाई के ऊपर, चाइना जो जमीन पे हमारे कब्जा करके बैठा उससे तवज्जो हटा दिया जाए. और हमारा मानना ये, हमारा एप्रीहेंशन ये है कि deliberately uniforms, there is a reasonable apprehension that by deliberately confounding the difference between UCC on the one hand and piecemeal reform of family law on the other, the present government wishes to avoid political consequences of obliterating the diverse customs prevailing in various Hindu communities that are presently protected under various applicable statutes, avoid dealing with tribal practices that have been granted protection or a constitutional scheme, and skirt the issue of tax benefits available to Hindu undivided family, each of which is necessary concomitant of a UCC that is enforced throughout the territory of India. Instead, it is reasonably feared that such an exercise will merely isolate Muslim personal laws and subject them to a reform process solely for political gain, and justify this process as being in furtherance of mandate Article 44, thus claim fulfillment of election promise. अब आप ये देख लीजिए, अब ये उत्तराखंड में जो हो रहा है, एक कमेटी बनाई गई, कमेटी ऑफ एक्सपर्ट्स ऑन लॉज रेगुलेटिंग पर्सनल सिविल मैटर्स, यूसीसी उत्तराखंड, एक नोटिफिकेशन दिए 27 मई 22 का. हमारा मानना ये है, इट इज नॉट इन फर्दरेंस ऑफ आर्टिकल 44 of the Constitution. Any code of law applicable only to one state is by its very definition not uniform throughout the territory of India, which is the clear language of Article 44. Therefore, it is clear that both at the center as well as the state level, the bogey of UCC is being raised only to target the Muslim community and polarize the atmosphere of political mileage. अब आप ये देख लीजिए, हमारा जो अब प्रीवियस ऑब्जेक्शन का फर्स्ट पॉइंट क्या है, इस देश में इमेंस डाइवर्सिटी है विद इन वेरियस ग्रुप्स और द लीगल ट्रीटमेंट. अच्छा, जो लीगल ट्रीटमेंट विच इज मेटेड आउट टू कल्चरल कम्युनिटीज डिफर्स इमेंसली and is non-uniform. For example, Muslims and Christian citizens of the country cannot access tax rebate under Income Tax Act available to Hindu undivided families. This reflects not only a mistreatment of how Muslims and Christians are treated in the country, but also reflects how accumulation of caste capital continues to receive legislative and constitutional protection. It is obvious that Adivasi and Dalit communities do not have access to accumulated intergenerational capital and therefore cannot seek taxation benefits under existing legislation. Secondly, the term UCC appears in Directive Principles. The Law Commission has not clarified again how uniform is confused with the Common Civil Code. It must be emphasized that our constitution makers clearly noted that code will never be imposed on citizenry merely because of citizens. Third, unlike Hindu law, which operates on strictly priestly and legislative interpretation, Islamic law, along with Adivasi and Dalit social practice, is not uniform and extremely contingent on context, cultural practice, social relations. Therefore, one sees that despite a permission of polygamy in the community, Muslims in practice rarely practice it. In other words, Muslim personal law and equal gender rights are never seen as contradictory but consistent with each other in practice. Fifthly, for codified Hindu law, family and social relations are extremely diverse within communities. For example, in Hindu Marriage Act under Section 2 recognize the rights of Adivasi communities to continue practicing their own customary law. Similarly, within Muslim various groups and subgroups observe extremely varying practices. Each of these practices is considered by such groups to be within the umbrella of Sharia or Muslim personal law. Such communities include sects such as Shia, Sunni, but also cultural groups such as Kachi Memons and Mapila Muslims, and schools of thought, Hanafi, Jafri, Salafi and other denominational schools of thought. Each of these groups' practices are influenced by each of these aspects. What are the aspects? And they cannot be classified into single monolith identity. The diversity of the country is too vast to be raised by single legislation of parliament. 6. Codification of personal law does not equate with equal rights. Besides the example of it must be noted that Hindu Marriage Act 1956 does not recognize that parties to marriage must exercise their consent. इस्लाम में कबूल है पूछते आपको, हिंदुइज्म में कबूल है नहीं पूछते, आपके रिचुअल्स जो मुकम्मल हो जाते शादी हो जाती. नंबर 1. However, are completely valid marriage. However, under Muslim personal law, unless the parties agree to marry each other, no marriage is valid. Any vitiation of consent makes a marriage void in Islam. 7th, a voluntary, secular, non-religious civil code already exists in the statute books in the form of SMA, JJ Act 2000, Indian Succession Act 1925. However, it is recommended a voluntary personal law system also be recognized. आप recognize करो इसको. Any community that seeks to preserve its distinct religious culture and social practices under Article 25 and 29 of Constitution must have the legal avenue to do so. 8. The operation of Muslim personal law shows that it is far more progressive than positive statutory laws like Hindu Marriage Act. In awarding maintenance and ensuring social care of women, relevant studies show that women receive a significant better deal under Muslim personal law than under laws. The abolition of such progressive and protective measures for Muslim women solely for achieving superficial uniformity will result in absurd amount of injustice for Muslim women. Finally, the impact of abolishing personal and customary laws will not only be felt by Muslim communities in the country, but will also harm constitutional protection guaranteed to citizens of the country. These include constitutional protection to Nagaland, Mizoram under Article 371A, 371G. Furthermore, cultural rights of Adivasi groups under Schedule 6 Constitution are also violated by any common civil code. In addition to religious rights protected under Article 24 of the Constitution, the most significant violation will be Article 29 of the Constitution. अब आप आखिर में देख लीजिए कि the UCC debate is ingrained bias in favor of the religious morality of the majority community. ये पूरा UCC का जो डिबेट है रिलीजियस मेजॉरिटी ऑफ मेजॉरिटी कम्युनिटी को आप इंपोज करना चाह रहे सबके ऊपर. द स्टार्केस्ट एग्जाम्पल ऑफ दिस इज द लॉ ऑफ डिवोर्स. इसका एग्जाम्पल दे रहा हूं आपको. जो कंसल्टेशन पेपर 21st लॉ कमीशन दिया था, कंसल्टेशन पेपर proposes that unilateral divorce by a Muslim man should be penalized. The debate in public domain has vilified unilateral divorce, which in turn has prompted petition Supreme Court challenging talaq-e-ahsan, talaq-e-hasan. The two, अब दो ही बचे हुए, the two remaining forms of unilateral divorce by Muslim man. हम ये क्यों बोल रहे? The underlying assumption debate has always that the process of divorce under Hindu Marriage Act 1956 is a superior method. यही तो बहुत मेजॉरिटी जो मोरालिटी है. when one more or more of adultery, cruelty, desertion, unsoundness of mind or conversion or other faith has to be alleged and proved before a court in trial before divorce can be granted. हिंदू मैरिज एक्ट में आपको बताना पड़ता है एडल्ट्री, क्रूरल्टी, डिजर्शन, अनसाउंडनेस ऑफ माइंड, कन्वर्जन टू अदर फेथ और उसको कोर्ट में प्रूफ करना पड़ता है बिफोर डिवोर्स इज ग्रांटेड. Similarly, grounds are seen in Divorce Act of 1869 of Christians. This applies to divorce between Christian and Special Marriage Act. That is usually cited as a shining example of egalitarian uniform law.
ABP Ganga, खबर आपकी, जुबान आपकी.